attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about the federal and Florida M&A Broker exemption. Following the SEC's lead, effective July 1, 2016, Florida passed a statutory exemption from the broker-dealer registration requirements for entities affecting securities transactions in connection with the sale of equity control of private operating businesses, called an M&A broker. New section 517.061(22) provides an exemption from the securities registration requirements for the offer or sale of securities solely in connection with the transfer of ownership of an eligible privately held company through a merger and acquisition broker in accordance with section 517.12(22). New section 517.12(22) in turn details the merger and acquisition broker registration exemption. Like the SEC no action letter, the Florida broker registration exemption pertains to persons and entities affecting securities transactions in connection with the sale of equity control of private operating businesses. Florida statutes define an M&A broker as one that is engaged in the business of effecting securities transactions solely in connection with the transfer of ownership of an eligible privately held company, regardless of whether that broker acts on behalf of a seller or buyer, through the purchase, sale, exchange, issuance, repurchase, or redemption of, or a business combination involving securities or assets of the eligible privately held company. Subject to certain restrictions, the Florida rule exempts the registration of an M&A broker that conducts transactions under Chapter 517.061. That is, a person that falls within the definition of an M&A broker and who completes transactions involving the offer or sale of securities solely in connection with the transfer of ownership of an eligible privately held company can collect fees, including success fees and commissions, and does not have to hold a securities broker-dealer license to do so. The Florida statute is more restrictive than the SEC in its definition of a privately held company, and in particular, the statute defines an eligible privately held company as one that does not have any class of securities registered or required to be registered with the SEC under the Exchange Act, or which files or is required to file periodic information, documents, or reports under Section 15D of the Exchange Act, and 2, in the fiscal year immediately preceding the fiscal year during which the M&A broker begins to provide services for the securities transaction, the company has EBITDA of less than $25 million or gross revenue of $250 million, with a provision for future adjustments for inflation. In the next LawCast in this series, I will detail the restrictions and particular obligations required to rely on the Florida statute. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.